Thank you.
Justice Kavanaugh?
You're drawing a distinction between intent and purpose, and you also, though, rely on the Henry case quite a bit from 1912 in the patent context. And there, the court said there must be an intent and purpose that the article sold will be so used, and then says it may also be inferred where its most conspicuous use is one which will cooperate in an infringement when sale to such user is invoked by advertisements. So advertisement as an example of when there is an intent and purpose. And then in Calum, which is argued that within a week of Henry back in 1911, Calum's the copyright case, of course. In the reply brief, the other side points out that you ignore Calum in your brief, but Calum itself says in the copyright context, the defendant not only expected but invoked by advertisement the use of its films for dramatic reproduction of the story. The word advertisement appears in both cases. Henry says intent and purpose. Get your response to that.
So let me take them in turn. I mean, Henry says intent and purpose, but it also says you can infer that sort of compound if you know that the user is going to use it unlawfully. And like, I mean, to me, the right way to look at this is consistent with the
I'm not sure it says that, but anyway, keep going.
Not maybe in the same line, but I think it says it elsewhere. At least that's what I take from the opinion. Maybe I'm misreading it.
Got it. Okay.
But that's certainly why we were relying on the Henry case, because you were providing it knowing it would be misused. So that's part of the answer on Henry. But again, then you get to Calum. And Calum, yes, like obviously if you have inducement cases, that's what advertising goes to. It goes to inducement cases. But inducement cases are, historically, if you look at all of the contributory infringement cases, inducements is the smaller subset, and the dominant subset is material contribution, where you're providing material support, substantial assistance to somebody you know that it's infringer. And that's why, you can get the people who are just packing and shipping the bootleg records, right? They don't care what's in the box. They're just getting paid for doing it. But you still say, and ours have said that they are liable. That's certainly the dominant common law rule. It's the rule in the trademark context as well. So let me just say a word about Calum. Calum, again, is a case where you have, the promoter of the motion picture that's made from the book. So it's an easy case. And the language they talk about, where Justice Holmes goes back to a couple of the Supreme Judicial Court of Massachusetts opinions and talks about indifference, the court specifically says we don't have to get into those niceties here. So what they're relying on in Calum, which is why we ignored it, is the purest form of dictum.
Got it. Thank you.